Hello everyone, how are you all? Today we are starting up a very special lecture series for Judicial Services Examination as well as for LLB students. The medium of this series will be English. And today I am taking up Indian Penal Code 1860. In this lecture series we will complete each and every important topic related to the understanding of Indian Penal Code 1860. We'll understand the doctrines, important sections, chapters, and important principles. And today, I am introducing you Indian Penal Code. As you know, Indian Penal Code is a branch of criminal law. And criminal law is a branch of public law which deals with definition, trial, and punishment of crimes. Criminal law may further be divided into two classes. You must note down. Number one is substantive law and the second one is procedural law. Substantive law, what substantive law means? Substantive law is the class of law which defines and punishes offences. Indian Penal Code is an example of the particular substantive law. And procedural law is the class of law which prescribes procedure for prevention, arrest, detention, investigation, trial, bail, etc. Code of Criminal Procedure 1973 is a great example of the procedural law. Friends, if we talk about uncivilized society, there was no criminal law. Every man was supposed to be attacked in his person or property at any time by anyone. The person attacked either succumbed or overpowered his opponent. A tooth for a tooth, an eye for an eye, or a life for a life was the rule which prevailed in those days. As time advanced, the injured person agreed to accept compensation instead of killing his adversary. Subsequently, a sliding scale came into existence for satisfying ordinary offences. Such a system gave birth to archaic criminal law. For a long time, the application of these principles remained with the parties themselves, but gradually this function came to be performed by the state. The germs of criminal jurisprudence came into existence in India from the time of Manu. You must note down. In the category of crimes, in Manu Smriti, Manu has recognized assault, theft, robbery, false evidence, slander, criminal breach of trust, cheating, adultery, rape, murder, etc. The penal law of ancient communities is not the law of crimes. It is the law of wrongs. Or, in English technical term, it is law of torts. Let me tell you about administration of criminal law before 1860, before IPC. When East India Company took over the administration of Bengal, Bihar, it found the Mohammedan law of crimes be well established at that time. But the Mohammedan law was full of shortcomings. Many of its principles were repugnant to good government, natural justice and good sense. Many of its rules were fundamentally opposed to what we say the Western conception of natural justice, order, progress and the good of the society. It was administered to all people irrespective of their caste and creed. The Mohammedan law of crimes was derived from the Quran Sharif. The procedure and punishment was very rigorous and was out of date to the people of 18th century. Many changes were introduced from time to time till in 1860 when the modern Indian Penal Code came into force on 1st of January 1862. The Mohammedan law of crimes was deficient in only other ways. It was left at the discretion of the judges, which made them arbitrary and corrupt. Uncertainty prevailed in the minds of the parties. The Mohammedan law of evidence was very technical and primitive, making conviction of the offenders were very difficult at the time. The Mohammedan law provided that no Muslim could be convicted on the evidence of non-Muslim. You must note it down. It also provides that there must be a specific number of witnesses before accused could be held guilty of any particular offense. means number of witnesses are important, not the weight of the witness. It also demanded direct evidence and testimony of witness. It required direct evidence and no circumstantial evidence to convict a person. It was very difficult, you can say that. Difficulty of proof made impossible to convict an accused. This led to a lot of lawlessness in the country and society. The then law scholar thought that the Mohammedan law of crimes could not keep pace with the progressive society without making some radical modification and amendments. The criminal law of India has been codified in the Indian Penal Code and in the Criminal Procedure Code. The former deals with substantive law of crimes, as I told you. It has removed all the deficiencies enumerated before and came into force, as I told you, on January 1st, 1862. Let's talk about some reforms in criminal law. The administrators of the East India Company realized from time to time that Mohammedan law needed to be reformed. It was left to Warren Hastings and Lord Cornwallis to carry out these reforms in a particular manner. You must note down the name of both the persons, Lord Cornwallis and Warren Hastings. Let me tell you about the reforms in criminal law carried out by Warren Hastings. It was in 1772 that Warren Hastings changed the existence of Mohammedan criminal law in order to suppress robberies and dacoities. He even criticized the existing Mohammedan criminal law, which was prevailed that time and well established. In order to regulate the machinery for administration of criminal justice in Bengal, Warren Hastings carried out reforms in 1772, then in 1774, and finally in 1780. He also suggested certain measures for reforms. Let me tell you something about reforms carried out by Lord Cornwallis. When Lord Cornwallis came to India in 1790, he considered seriously the state of administration of criminal justice. Lord Cornwallis realized that there was great need to reform the existing system of criminal law. The reforms that he introduced are: number one, through a regulation in 1790, Lord Cornwallis made the intention of the criminal as the main factor for determining the punishment. It was to be determined on the basis of general circumstances and evidence gathered. He also laid down that the doctrine of Yusuf and Muhammad should form the basis for determining the seriousness of crime and not Hanfi's doctrine. If you go to Mohammedan criminal law, you will come to know what is Hanfi's doctrine. Instead of amputation of arms and legs, he substituted hard labor or fine and imprisonment. This was done in 1791. In 1792, a regulation was also formed that if the relation of a murdered person refused or neglect the prosecution, the Court of Circuit were required to send the records to the case to the Sadar Nizamat Adalat for final orders. It was also decided in 1792 that religious tenets of the witness shall not be considered as bar to the conviction of an accused person. The Muslim law of evidence was also modified in the year 1792. On May 1st, 1791, a code which came into force be known as Cornwallis Code, containing 48 enactments, was framed. This laid down the general principles for administration of criminal justice in 1793. The regulation framed by government were codified according to the prescribed form. Until the year 1833, the Governor of Bombay and Madras and the Governor General of Calcutta, now Kolkata, and their respective council were authorized by Acts of Parliament of England to legislate for the territories outside the presidency towns of Bombay, Madras, and Calcutta, respectively. On the other hand, the Parliament was to legislate in respect of the presidency town itself. As a result of the power aforesaid, a number of regulations were passed for the governance of the natives of the country. But They did not touch the Hindu or Mohammedan law. Though the personal laws of Hindus and Mohammedans were exempted from the purview of regulations, yet they did not fact modify them in several aspects. Inasmuch as the Mohammedan criminal law in Calcutta and Madras and the Hindu criminal law in Bombay were so much affected by the year 1833 that they lost their original character. It has been said that the regulations were passed with a view to reduce the cruelties and the hardship of these criminal laws, Mohammedan and Hindu criminal law, and make them consonant with the British rules. But it may be pointed out that in doing so, the criminal law became a patchwork of enactments so confused that it was the first subject which invited codification. On the arrival of Lord Macaulay, you must know about Lord Ballington Macaulay. On the arrival of Lord Macaulay in India, the first Law Commission was constituted in 1834. Lord Macaulay was appointed as a chairman of the commission, and three other persons, namely, must note down the name, one is Cameron, one is Macpherson, and the other is Anderson. Cameron, Macpherson, Anderson, and Lord Macaulay. These three were appointed members of the first Law Commission. During the 4 years, 1834 to 38 of Lord Macaulay's stay in India, the draft of Indian Penal Code was prepared and produced. Lord Macaulay was the principal author, you can say it, he was the sole author of the draft, which is known as Indian Penal Code today, prepared by the first Law Commission of India, established in 1834. Although the draft of Indian Penal Code was ready by the end of 1838, yet it could be passed only in the year 1860. Various reasons were there, and due to various causes, it could not be passed earlier. Codification of criminal law was not favored by some of the judges in India. But the Indian Mutiny 1857, you must know about Mangal Pandey. It culminated in the passing of Indian Penal Code. Certainly, Indian Penal Code has been so masterly drafted that Sir Stephen, the well-known jurist, Sir James Fitzgerald Stephen, I am talking about, he was a well-known jurist on criminal law. He has remarked that it seems to the most remarkable, as I think it bids fair to be the most lasting monument of its principal author, Lord Ballington Macaulay. There is a fashion in literature which may diminish the influence and popularity of his other writings, but the Penal Code has triumphantly supported the rest of experience for upwards of 21 years, during which time it has met with a degree of success which can hardly be ascribed to any statute of anything approaching the same dimensions. It will be correct to say that while the draft, which later became Indian Penal Code, remained a draft for about 21 years, it received during this time a revision at the hands of the professional lawyer Sir Baron Peacock, a well-renowned jurist who was then law member and who later became the Chief Justice of the Supreme Court of Calcutta, you must know, and also later rose to be member of the Judicial Committee of the Privy Council. Okay, I was talking about the time of mutiny. After mutiny, the governance of India was transferred from the hands of company to the crown, as you are aware with the history, I think. And an extraordinary impetus was given to legislation by the change. The Indian Penal Code was therefore passed as an Act of 1860, and shortly afterwards as an Act of 1861 was enacted, which is called the Criminal Procedure Code. Now, considering the stages of progress which the Indian Penal Code underwent, I can conclude that the Indian Penal Code may be described as the criminal law of England, free from all technicalities and systematically arranged and modified in some few particular to suit the circumstances of British India. What for modern India? It is going through number of amendments, and much more amendments are awaited. So friends, I think you have now a better understanding about the historical background of Indian Penal Code. I have introduced you the Indian Penal Code, how it came into existence. This particular code consists of 23 chapters and massive 511 sections. And in this series, we are dealing with very important doctrines, principles, sections, chapters and segments of IPC. Stay connected. Have a nice time.